Article 129. Search warrants maliciously obtained and abused in the service of those legally obtained. In addition to the liability attaching to the offender for the commission of any other offense, the penalty of arresto mayor in its maximum period, 2 prisión correccional in its minimum period, and a fine not exceeding 1,000 pesos shall be imposed upon any public officer or employee who shall procure a search warrant without just cause, or, having legally procured the same, shall exceed his authority or use unnecessary severity in executing the same. Acts punishable in connection with search warrants. Number 1, by procuring a search warrant without just cause. And number 2, by exceeding his authority or by using unnecessary severity in executing a search warrant legally procured. Elements of procuring a search warrant without just cause. First, that the offender is a public officer or employee. Second, that he procures a search warrant. And third, that there is no just cause. Now, what is a search warrant? A search warrant is an order in writing issued in the name of people of the Philippines, signed by a judge and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. Personal property to be seized. A search warrant may be issued for the search and seizure of the following personal property. First, subject of the offense. Second, stolen or embezzled and other proceeds or fruits of the offense. Or third, used or intended to be used as a means of committing an offense. The requisites for issuing a search warrant. A search warrant shall not issue except upon probable cause in connection with one specific offense to be determined personally by the judge after examination under oath or affirmation of the complaint and the witness he may produce, and particularly describing the place to be searched and the things to be seized, which may be anywhere in the Philippines. Examination of complaint. The judge must, before issuing the warrant, personally examine in the form of searching questions and answers, in writing and under oath, the complaint and the witnesses he may produce on facts personally known to them and attach to the record their sworn statements together with any affidavits submitted. The right to break door or window to effect search. The officer, if refused admittance to the place of directed search after giving notice of his purpose and authority, may break open any outer or inner door or window of a house or any part of a house or anything therein to execute a warrant or liberate himself or any person lawfully aiding him when unlawfully detained therein. Search of house, room, or premise to be made in presence of 2 witnesses. No search of a house, room, or any other premises shall be made except in the presence of the lawful occupant thereof, or any member of his family, or in the absence of the latter, in the presence of 2 witnesses of sufficient age and discretion residing in the same locality. Validity of search warrant. Search of house, room, or premise to be made in presence of 2 witnesses. A receipt for the property seized. The officer seizing property under the warrant must give a detailed receipt of the same to the lawful occupant of the premise in whose presence the search and seizure were made, or in the absence of such occupant, must, in the presence of at least 2 witnesses of sufficient age and discretion, residing in the same locality, leave a receipt in the place in which he found the seized property. Now let's discuss the case of U.S. v. Addison in relation to Article 129 of the Revised Penal Code. The facts are as follows. The appellant subscribed and swore to an affidavit wherein he stated that he saw various bottles containing compounds of opium in an aparador situated in the house of John Maxtay. On the same day, the CFI issued a search warrant based upon the affidavit. directing the sheriff to search the house of Maxte and seize the opium. In compliance with this warrant, the sheriff proceeded immediately to search the house, but found nothing of a contraband nature and reported to the court. The issue in this case is whether or not there is probable cause for the issuance of the search warrant. The court ruled that under Article 129 of the Revised Penal Code, it requires that both malice and absence of probable cause must exist concurrently in order to justify a conviction. If the appellant's act in making the affidavit was malicious and unfounded, but there was probable cause for such act, he must be acquitted. Malice cannot be inferred from the fact that no opium was found in the house of the complainant by the sheriff. Addison was induced by the Internal Revenue agent to make the affidavit. In so doing, he was carrying out his obligation as an informer, and as such informer, he had reasonable cause to believe that he would be rewarded therefor, in accordance with certain provisions of the opium law. We must, therefore, conclude that there was an absence of malice on the part of the defendant in making the affidavit and that there existed probable cause for making the affidavit.